Good afternoon, and welcome to today's Citizens Training. We're going to go ahead and get started. We've got a couple of people that will be joining us, but they can go ahead and hop on, and we'll be recording this audio so people can always play it back if they want to hear additional pieces of anything they may have missed. I am Mary Clemenson with the Chesapeake Legal Alliance, and we are excited to bring you today's training in partnership with the Midshore Riverkeeper Conservancy. You have joined us today for participation in Maryland's National Pollutant Discharge Elimination System, NPDES, permitting process. This is a public seminar and a companion training to our recently released Citizen Guide by the same title. This guide document is available in the GoToWebinar dashboard, so you should be able to see that on your little dashboard there, and you should be able to download the guide directly. But this is also available on our website. If you have any issues downloading it, go ahead and submit a question, and we'll try to work it out while we're doing the presentation. After today's presentation, we will be taking questions. You can submit questions throughout the presentation through the GoToWebinar question box. Don't worry about holding your questions to the end, though. You can go ahead and enter them as you think of them throughout the presentation, and then we will get to them at the end. An audio recording of this presentation will be made available on the Chesapeake Legal Alliance and Midshore Riverkeeper Conservancy websites, so you can look at it there and share it later. I would like to briefly introduce our speakers today. I will then ask them to tell you a little bit about their organizations after I provided a brief introduction. I'm going to start briefly with myself. I'm a staff attorney at the Chesapeake Legal Alliance, and I'm responsible for pro bono legal services in New York, Pennsylvania, Delaware, and the upper part of Maryland. I earned my law degree from Vermont Law School and Bachelor's of Science from the University of Illinois. Our organization, CLA, coordinates a network of lawyers who volunteer their time and professional skills free of charge to help environmental organizations, citizens groups, and individuals in their efforts to improve the health of the Chesapeake Bay and its watershed. CLA volunteers provide legal support and citizen education on topics like the one we're talking about today. And actually, Jill Grant is one of our CLA volunteers, so we're very happy to have her here with us today. Today we have with us Matt Pluta with Midshore Riverkeeper Conservancy and Jill Grant with Jill Grant Associates. Matt Pluta has been the Choptank Riverkeeper since 2015, and with that organization, he focuses his efforts on bringing awareness on issues impacting the Choptank River, implementing cleanup projects, and advocating for healthy waters in communities in the area. Matt also worked for Environment Erie as a program manager and Penn State Institute of Energy and Environment as a field technician. Matt earned his Bachelor's of Science from Penn State. Our other speaker today, Jill Grant, is the principal member of Jill Grant Associates and has extensive background in environmental, administrative, and federal Indian law. Jill is also the CLA volunteer who was the principal author of our NPDES guide. Before starting her own law firm, Jill was a partner in private practice and was an attorney at the U.S. Environmental Protection Agency in their Office of General Counsel. She earned her law degree from Harvard Law and her Bachelor's of Arts from Yale College. And so now I'm just going to ask Matt and Jill to provide a little bit of information about their organizations. We'll go ahead and start with Matt.
Great, thanks, Mary. As a really quick introduction, Midshore Riverkeeper Conservancy is a nonprofit on Maryland's eastern shore dedicated to the protection and restoration of the Choptank, the Miles, and the Wye River, their watersheds, and all the resources that they support. In order to help meet our mission, we have 10 full-time river advocates. That includes a robust education program, an agricultural outreach program, water quality monitoring, and 2 riverkeeper programs, the Choptank Riverkeeper and the Miles and the Wye Riverkeeper.
And hi, I'm Jill Grant, and our law firm represents governments, including tribal governments and other organizations on environmental issues. We both help developing environmental programs, drafting environmental laws and regulations, and also address specific issues such as Superfund sites and conduct litigation.
Great, thank you both so much. And with that, we will begin. So today's presentation really focuses mostly on the Maryland process for the NPDES permitting program. And then we're talking a lot about what that permitting program looks like, the process within the agency that implements that permitting process, and then also how public can participate in that. So that's citizens or interested organizations that might be working in this area, or anybody who may just have an interest, really, from citizens all the way up to large nonprofit organizations. And to provide a little bit of background about that, we're also going to go through the Clean Water Act really briefly, just to provide some context, because the Maryland program is derived from the standards that are set by the Federal Clean Water Act. And then after that, we're going to implement the information that we've gone through an example permit. And then we're going to talk a little bit about how you can take action on this information and share the guide and this and other toolkit options moving forward. And then we will take questions and answers at the end.
So good afternoon again, this is Jill. I'm going to start us off by providing a little background on the Clean Water Act and on the NPDES or NPDES permits to provide some context for the citizen guide that we're discussing today. The Clean Water Act was one of the first federal environmental laws to be enacted, and it's been amended several times, most notably in the 1970s. It's intended to clean up the nation's waters by limiting discharges of pollutants and prohibiting toxic discharges into those waters. It's also intended to maintain good water quality, including protecting the use of the water for fish and wildlife as well as for people. It was one of the first federal environmental laws to contain a permit program, which is an important way of implementing environmental requirements and which is going to be our focus today. So as we've listed on this slide, the Clean Water Act requires EPA to establish technology-based standards for industrial facilities discharging into water bodies. There are two types of these standards: effluent limitation guidelines, and for new sources, new source performance standards, and they apply nationally. They set the maximum allowable levels of pollutants that can be discharged by a facility. The Clean Water Act also requires states to establish water quality standards for their state. It requires each state's water quality standards to include the components listed on this slide. Basically, the state identifies the waters within its jurisdiction, designates the various uses of those waters, and then sets water quality criteria and standards to support those uses. The standards are both in numeric and narrative format. So water quality standards also must contain an anti-degradation policy to protect existing water uses and preserve high-quality waters. And the standards can also contain other general policies, such as addressing mixing zones and variances. The technology-based and the water quality standards are implemented through the National Pollutant Discharge Elimination System permits, which is quite a mouthful, which is why we're calling them NPDES permits. And we'll be discussing that for the rest of the webinar. But first, I'll just mention that the Clean Water Act includes two other regulatory programs in addition to the NPDES program. These are the permit program for discharges of dredged or fill material, and those permits are issued by the Army Corps of Engineers and commonly arise in the context of construction and development affecting wetlands. The other program establishes spill prevention requirements and provides for responses to accidental spills of oil and hazardous substances into the waters of the United States. These provisions were added by the Oil Pollution Act and were overseen by EPA and the Coast Guard. But turning back to the NPDES program and the NPDES permits, Section 402 of the Clean Water Act prohibits the discharge of pollutants by point sources into the waters of the United States if they don't have a NPDES permit. In this way, the permit becomes the means for limiting the amount of pollution entering into the water. The NPDES permit limits, terms, and conditions are intended to protect water quality in the receiving water body, as I'll discuss in a minute. States with NPDES programs that are as strict and comprehensive as the Clean Water Act and the federal regulations are authorized by EPA to administer their own NPDES programs, and Maryland has met those requirements. That means that the Maryland Department of the Environment, or MDE, issues the NPDES permits in the state of Maryland. EPA does still retain oversight for the program and can step in if MDE isn't carrying it out correctly. And EPA also can step in to enforce permit requirements if MDE isn't doing so. But the daily running of the program is left to MDE. So going first to who needs a NPDES permit, I said before that a discharger of a pollutant through a point source into a water of the United States requires a NPDES permit. but those names, all in quotation marks, are all terms of art under the Clean Water Act. Starting with the first and last ones, discharge and waters of the United States. A discharge of a pollutant is defined in the Act as the addition of a pollutant to navigable waters. And then the Act defines navigable waters as waters of the United States. Waters of the United States are not defined in the Act, but are defined by regulations issued by EPA for NPDES permits, and also by the U.S. Army Corps of Engineers for dredge and fill permits. They include most surface waters, such as rivers, streams, and their tributaries, and estuaries, like the Chesapeake Bay, and they may include certain lakes, ponds, and wetlands. There's been a lot of debate as to which of those latter types of water bodies are subject to the Clean Water Act, and the issue is still unresolved, even after several cases have gone up to the Supreme Court. In 2015, the two agencies, EPA and Army Corps, revised the waters of the U.S., or it's called WOTUS rule, in order to try to clarify some of the issues. However, pursuant to a Trump executive order, they've just proposed to rescind that rule and go back to the old regulations pending the drafting of a new WOTUS rule. And meanwhile, the 2015 WOTUS rule is being litigated. So there's still a lot of uncertainty as to which of these other types of water bodies, the lakes, ponds, and wetlands, are actually covered by the Clean Water Act. And that issue mostly arises with respect to the dredge and fill permits and wetlands, but it can arise with NPDES permits as well. Turning to the next term, pollutant. A pollutant can be a broad range of substances as listed in the Clean Water Act, and the definition is reproduced on the slide. These pollutants, which you can see cover basically everything, are divided into three categories. There's regulated conventional pollutants, and there are 5 of those. You'd probably see them in a permit if you were reviewing the permit. They're biochemical oxygen demand, total suspended solids, pH, fecal coliform, and oil and grease. There's also toxic pollutants. There are, I believe, 65 of those. And then there's non-conventional pollutants, which is basically everything else. The term pollutant does not include sewage from vessels or injected waste, which are regulated under separate provisions of the Clean Water Act and the Safe Drinking Water Act. This slide also reproduces the Clean Water Act definition of a point source. Point sources generally discharge from a discernible location, such as a pipe or ditch, but they also include more widespread sources, such as concentrated animal feeding operations, which are known as CAFOs. Some common facilities with point sources are sewage treatment plants, manufacturing plants, power plants, and storm sewer systems. A point source does not include return flows from irrigated agriculture or agricultural stormwater runoff. Those sources do not require permits. This next slide explains how the NPDES permit requirements are determined, assuming all those other steps are met. They're generally determined by considering the pollution control technologies available for the type of facility, and that results in the technology-based requirements I mentioned earlier, and also the quality of the receiving water body, resulting in the water quality-based requirements. These considerations are implemented through the effluent limitations contained in the permit. You'll find these stated in the permits as pounds per day or milligrams per liter, and as an average monthly limit combined with either a maximum daily limit or an average weekly limit. Matt is going to be providing an example of this later. There are also 2 types of NPDES permits, individual permits and general permits. Individual permits are issued to a specific facility based on site conditions, whereas general permits contain standard requirements for particular types of facilities or discharges, such as stormwater discharges from construction sites or CAFOs. We're largely going to be discussing individual permits here. Finally, there are TMDLs. When water quality standards are not being met in a particular water body, the state must determine the total maximum daily load, or TMDL, of a pollutant that can be discharged into the water body and then allocate it in the permits for all the point sources discharging into the water. The state can also establish water quality plans for sources that are not subject to NPDES permits, such as for agricultural stormwater or irrigation runoff. You're probably most familiar with the TMDL that's been established for the Chesapeake Bay. The next slide. So next, we're going to turn to Maryland's NPDES permitting process. And then Mary's going to discuss in more detail the opportunities for public involvement in that process. Are we stuck? While they're pulling up the slide, the first slide lists the different stages in the permitting process for individual permits. It's also contained in the flow chart on the next slide, which might be easier to follow. So in a minute, I'll turn to that. Before I do, though, I'll just note that the procedure for general permits as opposed to individual permits is kind of the same, but it's more abbreviated and is discussed at pages 12 to 13 of the guide. We're not going to discuss it here. So going to the flow chart, you'll see that the, well, the first step is just that the discharger submits an application for an NPDES permit or a permit renewal or modification, and that's submitted to MDE. And then MDE publishes notice of the application in the newspaper and also will post it on the MDE website. The notice includes information on how the public may request an informational hearing about the permit, when MDE and sometimes the applicant will explain the discharge and its effects. The next step would be the informational meeting if it's been scheduled, and during this time, MDE also will be drafting the permit. At the third step, MDE issues public notice of the draft permit, which will be accompanied by a tentative determination explaining the basis for MDE's decision on the permit. MDE also issues a fact sheet about the permit if it's for a major discharger or in some other circumstances, such as when variances from the standards are being requested. The public notice begins the 30-day public comment period. The public also can request a public hearing at this time if one hasn't already been scheduled. At the end of the public comment period, if no substantive comments are received, then MDE just issues the final permit. If there have been comments, then MDE must consider those comments and then issue a final determination responding to them and also include the final permit. Finally, in step 5, any person who commented on the permit and who disagrees with the final determination may challenge the determination in the circuit court for the county where the discharge will occur. Judicial review of the permit is limited to the issues raised during the public comment based on the administrative record, which consists of all information in it. And now I'm public involvement process.
Great, thank you so much, Jill. I really appreciate that overview. And you'll see on the next slide, for the slides not changing, we're having some technical difficulties on our end, but hopefully everybody should be seeing the appropriate slide now. If not, just let us know through the question section at the dashboard, and we'll try to fix things. So I think we're squared away now in this process. So this slide provides a really good overview of the steps on the left that MDE would be going through, and then on the right, how the public can participate. And we're going to go through those now step by step. And if there's ever any specific details that you have questions on, please do submit a question or also refer to the guide, because all of these specific issues are addressed in the guide, and in particular, web links and other ways to get to some of the resources that we're going to talk about. So the first step is the pre-application process. And at this point in time, you want to take a look at if you either know there's a point source in your area that you may be concerned about, or if there is a known facility that you know has had violations in the past that you may be concerned about, or potentially you don't know about what kind of point sources are in your area. In that case, you can check out some of the great resources that are available to determine what point sources do exist in your area. And one way you can do that is to check out MDE's Wastewater Permit Interactive Search Portal. You can also go to EPA's ECHO database to check out any violations that a facility that has an existing NPDES permit may have. And you can also see their permit information there. And there you can look at their compliance history. And then some other stuff that you might want to do in the pre-application phase, that is before an application for a NPDES permit or an update to a NPDES permit has been filed with the MDE agency, is to get a base level of understanding of the state and federal laws. You know, read through the guide that we've provided, and then also you can read EPA's Permit Writer's Manual. That's a manual that EPA actually put out for those who draft NPDES permits. So that's a manual that provides a really great framework of what the NPDES permit program requires. And then you can go ahead and start taking a look at what facilities are in your area and what kind of technologies they might be using. So a continuation during this pre-application process, as you're looking at the facilities in your area, you want to also take a look at the types of water quality in the receiving water bodies. So if you know there's a local facility, you want to take a look at, well, what is the designated use and what are any requirements for standards, which we'll get into in a little bit more detail moving forward for that water body. And you want to take a look and see if there are any existing facilities, like I mentioned, that are already on that water body. You can also do that through My Waters Mapper. That is an EPA website. And then another really great thing to do in this stage is to talk with other people in your community who might already be up to date on these types of questions and issues. So riverkeepers or watershed groups are great examples of people and organizations that may be tracking this information and can help you either get a look at where you might want to start in the process, or how they could use your assistance, or how you might assist them. Local colleges are a really great research tool, and they can oftentimes help with water quality samples, which we can get into a little bit more in a couple of slides. And you want to take a look at if there's any existing information about the facility. So if you have now identified the facility that you're looking at and you know they either have a permit or they're applying for a permit, or maybe you think they need a permit, you can take a look at, well, are there any samples to say what the water quality of that water body that they're discharging into is existing currently. And if you have some concerns about things that might be being discharged into that waterway, you might want to take photos, document the condition of the water or any point sources that you're seeing going into that water. And this may be useful later on in other stages. And if you're doing that, do try to note GPS locations, because that's going to be useful if you ever do actually submit comments or talk to the agency about it. The other thing to consider is, does a TMDL apply? So that stands for total maximum daily load. And if you have a water body that's not meeting water quality standards, which is based on the designated use, and we'll get into how you kind of determine that in a little bit later, you want to think about if they're meeting this total maximum daily load of pollution entering the stream or the water body. And for short, we call it a TMDL because it's also kind of a large term. So the next step in the process is to get notice of the permit and map out the timeline. So once you know the facility you're looking at and you have a little bit of background information about it, you're going to want to take a look for notice of a permit coming up. And you may have already seen this. This might be what triggers your interest with a facility or your understanding of it. And at that point, you want to take a look at how you can stay up to date on information about the permit as it moves forward. Some ways to do that is that MDE and Maryland Register, they provide a lot of information about the permits because they are legally required to provide notice for draft determinations, final determinations, and public hearings. And that information will be in public notices. And something to think about too is there's oftentimes contact lists where if you are interested in a specific facility, you can reach out to MDE and say, hey, I'm interested in this poultry facility, and could you put me on any email list that you might have that will send information out about any permit updates or upcoming permits. And sometimes you can also build relationships with MDE staff to get a good feel for when something might be coming up on a particular area, and Matt can talk to that a little bit later. So as the slide denotes, the Maryland Register puts out information every 2 weeks for general permits. Jill outlined a little bit earlier the difference between a general permit and an individual permit. And so the notice requirements are slightly different. So the general permits will be put on the Maryland Register, and you can also visit the public notice and information website to see existing current public notices that might be available. At this time, you also want to take a look at, once you have the information, creating like a calendar or a timeline so you can track what's going to be happening with this permit and some of the steps that we're talking about. And if it's an individual permit, you can submit an informational meeting. So if you get notice of a permit that is coming up and MDE is considering drafting a permit for a facility, you can ask them for an informational meeting. That is a meeting before the agency has drafted the permit. And oftentimes in that meeting, the actual facility operator might be there, or the person who's requesting the permit. And that's a really great opportunity to ask questions about what will be happening with this permit and get some information about what the facility is looking to discharge or potentially change their permit to or get a permit for. So after you've done that, you're going to take a look at strategy and involving other parties. This is a really great time to kind of stop and think, you know, what is going to be in this permit? Is it already a protective permit? Do we need to be commenting on it at all? Sometimes the best way to support a permit is actually to submit comments, but in support of, if you think MD is actually putting in some good requirements. You also want to take a look at if you want to comment based on whether the facility has previously had violations, or if the water quality standards for the water body in which the facility would discharge are not meeting those standards. So you know that the water quality of that water body is in need of help of some pollution reduction because it's not meeting its designated use, which is like swimmable or fishable. You might want to consider providing comments then to take a look at, you know, how this permit could be changed to make sure that the water body can meet the set water quality standards. And then take a look at this point if you're going to need any technical experts. Sometimes the permits can get complex. There may be some technical jargon or information about the process, and the facilities can have very complex technology. And then this will help you understand if you might need to start reaching out to experts either on the technology side or someone just to help you look through the permitting process like an attorney. And so you can also consider if you need to outreach to attorneys. Chesapeake Legal Alliance is a great resource for that, and we want to make sure that everybody knows that we are here to help with these types of things. So this is a guidance, you know, to try to get you started. But if you find that you're meeting challenges or you need some help in commenting on a permit, please let us know, and we're happy to try to assist. That is what we do. And then also legal clinics, local attorneys that might want to do pro bono work. There are a lot of resources out there. The key to really think about is earlier the better. The earlier that you can get in front of a permit and start leveraging resources from other organizations that might be following this permit, the better off you're going to be situated to really put together a really great set of comments to submit to the agency. So the next slide talks about standing. This is also a legal term of art, which essentially indicates if an individual or organization has been harmed or will have some kind of impact from the action that's happening. And this is something that's really important to think about early and often. So just submitting comments will not set you up to challenge the permit with a legal challenge at the end. Only individuals and organizations that have standing and who have also participated in the public participation process can maintain a petition for judicial review of a permit decision. If you're a concerned citizen, but you don't use the body of water that's in question, you might not have standing. This is another great point to take a look at your resources, both legal, technical, and local river keepers and other organizations to see if they might also know somebody who has standing, if you do not, and then you can work together and ensure that the individual organization that may have standing submits the comments, but you can all kind of pull your resources together to, you know, really get through this entire process and submit the best set of comments possible. And at the bottom of the slide are some questions to consider if you have standing or not. These are outlined in more detail in the guide, and there's a lot of specific things, and it's really a case-by-case determination. So we really encourage you to take a look at this and reach out to experts, including CLA, if you need any assistance deciding if you have standing to potentially challenge a permit decision at the end of the process if you do not like what comes out in the permit. So on the next slide, you want to take a look at important documents and information and really get all of your ducks in a row and start considering the various water quality standards that are supposed to be met for that water body, and take a look at any violations that may have occurred in the past, and then take a look at how you might be able to get this information. So a lot of information, including tentative determinations, which is MDE's initial review of a permit and saying we're likely going to be providing a permit for this facility and this is what's being requested and we're initiating this process. Final determinations, fact sheets, and draft permits, these should all be publicly available, and you can find this information when the draft determination is released to the public, and they should all come together. But you can also file what is called a Maryland Public Information Act request, or a PIA request. So it's really great to take a look at what you can do through the PIA to get documents that may help you analyze the permit or future permit. This information includes past permits, past performance of those permits, violations from that facility, discharge monitoring reports, or filings from past hearings or litigation. Also, it may include correspondence between the facility and agency. So those are documents that you can get to really help inform the comments that you'd be submitting. And then I'm going to hand over the next couple slides to Jill.
Okay, so these next slides go back to material we discussed at the beginning. As we talked about, NDE will have designated the uses for all the waters of the United States and the state of Maryland, and also assigned the criteria needed for those uses. So this slide lists the different uses of Maryland waters. You can see it includes water contact recreation, so things such as swimming, where you might actually swallow the water. It also includes water used for drinking water, and it includes waters that are used for various fish and aquatic life. The following slide lists the different types of criteria that are then set for these different uses. And it also lists the 3 tiers of water quality used for anti-degradation purposes. And I'll just note here that Maryland has not designated any Tier 3 waters, which are those with the outstanding water quality. This next slide, Analyze the Permit and Request Public Hearing, is referring back to step 3 of the permitting process. And it notes that if NDE hasn't already scheduled a public hearing, you should consider submitting a public hearing request. The request must be made in writing within 20 calendar days of publication of the notice. Before attending the hearing, and probably even before deciding whether to request one, you'd want to review the draft permit to see what issues to raise. Some examples of issues are listed here, and they're explained further in the guide as well. So, for example, you might check the applicable effluent limitation guidelines against the effluent limitations in the permit to see whether they're consistent. You also might compare the draft permit with the facility's existing permit if this happens to be a permit renewal, to make sure that the requirements remain at least as stringent as they were. And you could also refer to EPA's ECHO database, which is discussed in the guide, as to any past violations at the facility that should be considered. And also you can review information from past facility hearings or litigation discussing past performance. Some of the other suggestions listed here may require more technical expertise. For example, if a new or increased discharge is proposed that may impact the Tier 2 water, you could check to see whether an anti-degradation analysis was performed, and that can be quite complex. You also can examine the monitoring and reporting requirements to see if they seem adequate. There isn't any particular standard for them. You can determine if net credits are granted because the facility can't meet effluent guidelines, and if so, whether they're appropriate. determine whether particular water quality-based effluent limitations should be included because the technology-based ones are not doing the job. And if the water body is impaired, then the permit is subject to a TMDL. You could check whether the draft permit contains a waste load allocation. More information on these is provided on pages 30 to 34 of the guide. And also to assist you with these more complex issues, you may want to consult with someone with expertise in those areas.
Great, thank you so much, Jill. So the next step to think about is preparing for and attending any public hearing. So like we mentioned earlier, you can request a public hearing for an individual permit. Public hearings are also potentially available for general permits, but are at MDE's discretion. Public hearings are your opportunity to learn more about the draft permit and to make comments in a public forum. So you can ask for explanations about things that are included in the permit or anything that you may not understand. Some things to note here is that it's really, really great if you can be as prepared and organized as possible. Make sure that you have all your materials with you in an organized fashion and have any comments that you are looking to submit or questions to ask decided before you go into that hearing. And if you're working with other partner organizations, you may want to sit down with them beforehand and chat about who's going to ask what questions and who's going to discuss what pieces of the permit. And this is also a good place just to note you can always support issues too. So if there's something that you think that is great that MDE is doing in the permit, you can support that. And you can do that through your written comments as well. Some other things to consider in the public hearing is that you should definitely take notes because a lot of times the transcript won't be available until afterwards. So if there's anything of importance that's raised in the public hearing, you go ahead and note that so you can include it in your comments. And then you're ready to submit written comments. And really, this is what you've kind of been preparing for, is gathering all your documents and looking at all the technical aspects and gathering the information you can in the public hearing to get a sense of maybe where MDE is going with various requirements. And then you can write your comments, or I should say you should write your comments in a written format and submit that to MDE. Some things to think about there is that you can provide your written comments. You don't have to wait until after a hearing. If there is a public hearing, you can provide them at any point in time during the public comment period, so long as it is before the public comment deadline. There is a public comment deadline, and it's usually 30 days after the notice's publication. And so you're going to make sure you do get them in beforehand, but you don't have to wait until after the hearing itself. And you can also submit them after, you can submit a second set of comments after the hearing. So let's say you submitted comments early on in the process, and then you go to a public hearing, and there's a couple things talked about that you want to add additional comments on. You can go ahead and address those in a second document that you submit to MDE for review. And there's some things here to really keep in mind when you're writing your comments. Some really important ones are to remember that you're putting the permit number and name of the facility on all the pages. Start with your best arguments. Try to keep it clear and concise. And comments should be submitted 30 days after the notice of publication, unless otherwise specified, or if there's an extension of the public comment period. Sometimes there will be an extension. You can also request an extension of the public comment period. You have to give rationale for that, but in certain circumstances, MDE will grant that, and we can always chat about what that looks like and how you do that. So finally, you are at the final approval and enforcement stage. At this point, you take a look at the final determination that MDE makes, and you decide what they did. If they incorporated your comments, then that's great. Congratulate yourself. You really helped water quality in your area. If you disagree with MDE's final determination and you think they should have done something different, you do have the possibility, so long as that you have standing and you have submitted public comments, to challenge the permit in the circuit court for the county in which the discharge will occur. Make sure that you're considering standing requirements and that you do have standing, or that somebody has standing who is submitting the challenge. And remember that judicial review is limited to any objections that were raised during the comment period. There are a few exceptions there. For the most part, it needs to be on the record for what was reviewed by the agency at the time. And then you want to follow that permit. So if you decide to go ahead and challenge that, consider retaining legal counsel. CLA is a great resource there. Also other legal resources that might be available to you. And then once you have either challenged the permit or perhaps decided not to challenge the permit, you should certainly take a look at following the permit and tracking the facility's compliance, because there's always the opportunity potentially for MDE to amend or change permits if there is new information that arises. And there's also the ability for citizen suit enforcement. So that means bringing a lawsuit for a permit violation that can be enforced by a citizen lawsuit. So that's actually a different type of legal action. So instead of challenging the permit itself and saying this permit is not sufficiently stringent under the Clean Water Act, you are challenging a violation of that permit, or you're saying that there is a violation that permit doesn't cover that is a violation of the Clean Water Act. So that's another thing to consider even if you haven't engaged in the permit process or you're after the permit process. And now we're going to hand it over to Matt to talk about a real-life example of a permit that Mid-Shore Riverkeeper Conservancy has worked on in the past.
Great. Well, thanks, Jill, for the background on the Clean Water Act and going through the NPDES permit program in Maryland. Thank you, Mary, for laying out the details of the guide here. I'm real excited to be talking about this example of NPDES permit renewal because it was when I was navigating this permit process with a volunteer attorney from Chesapeake Legal Alliance that we started to discuss the need for a citizen's guide and identifying the opportunities where somebody could get involved at the many different stages of this permit process. So, jumping right into it, Allen Harim's Food is a poultry processing facility on the eastern shore in the Choptank River watershed. This facility has a permit to discharge 750,000 gallons of processing wastewater into a Class 1 stream. The effluent or discharge from this facility was a toxic cocktail that included ammonia, nitrates and nitrites, BOD5, total suspended solids, oil and grease, fecal coliform, and phosphorus. On this next slide here, I'm going to show you two diagrams that you saw earlier in the presentation. And my goal here is to walk you through the permitting process and highlight the different opportunities to get involved and some tips and some real-life examples on what we did while going through this permitting process. So breaking it down into the first pre-application period, this is better understood as how did you find out about this permit? What brought your attention there? In our position as riverkeepers, it's always a good idea to do a periodic compliance sweep of all the NPDES permits in your watershed or area of interest. You can do this by using the ECHO database, and it's beneficial because it lets you identify those facilities that are bad actors or that have a history of non-compliance, and it also helps you identify who the heavy hitters are in your area, or who are those facilities that have a permit to discharge a significant amount of wastewater into the local surface waters. In a perfect world, once you identify these problematic facilities, you'd start to identify partnering groups and supporters nearby those concerned facilities. You should locate these individuals or these groups, figure out if they're aware of the NPDES permit for that facility, understand if they are concerned, and then you should engage them using this citizen guide. To talk specifically about the Allen Harim permit, the facility's permit was actually expired in 2010, but because of the lack of resources at MDE, the expired permit was administratively extended, allowing the facility to operate under their old permit conditions for about 5 years. So at this point, MDE will publish a notice that they received an application, and they'll begin to draft the permit. Once this happens, you want to begin to develop your strategy. And we developed a twofold strategy when it came to this permit. Our first was to do a PIA request and collect and organize information, and then also start to seek legal assistance. This is the stage where MDE notifies the public that they received the permit application. Understanding that this permit was expired in 2010, I did not start working as a Choptank Riverkeeper until 2015, so this is where I jumped into the process for this permit, and I started by developing the strategy as shown on the screen. Here's an example of the PIA request letter that we submitted in order to gain information, to collect documents, and to start organizing all the resources. You can conduct a PIA request online through MDE's website, or you can submit a letter the old-fashioned way to the department. I prefer to submit a letter because that allows you to include more details and to be very clear on what you're asking for. When you're writing your PIA request and choosing what documents to request, include as much as you can and be as specific as you can. If you are not specific, you will find yourself going back and forth with the department to clarify some of your requests, and that could cost you time. And in certain circumstances, you don't have a lot of time to collect your information and to start to build the record. There's often a fee associated with the PI request to cover the time that the department staff need to search for the information that you requested and for any copying or mailing of the documents to you. You can potentially get this fee waived, as mentioned earlier, by offering to go and visit the files at the office where they are located. And if you do get that opportunity, bring a thumb drive with you, offer to scan the files on your own, so that way you won't be charged for any copying fees or any mailing fees. Here you'll see a list of some of the information we requested in our PI request. Those include any NPDES permits for the facility, which we knew they already had, the new permit application. We wanted all of the discharge monitoring reports for 3 years so we could understand any violations. And in addition to that, when a facility violates their permit, they're most likely required to notify the department of that violation. So we wanted any documentation of those violations that was sent from the facility to the department. We also wanted to know about any spills or overflows that occurred that were not permitted. And we also wanted to collect any correspondences between MDE and the owner of the facility. And this is a good one because it helps you understand exactly what the relationship is with MDE and the facility, and any information or any discussions that are going on about any violations that occurred. And then as a catch-all, you want to include any studies, statistics, reports, recommendations that may have been made throughout the permitting process. Here you'll see some examples of some of the documents that we received through the PIA request. Here you have any of their old permits and their fact sheets. These will highlight the effluent limits and any special monitoring or maintenance conditions included in the expired or old permit. You also want to find the permit application to help gain an understanding for how the facility operates and what they plan to discharge. On the right side of your screen, you'll see an example of a discharge monitoring report, and this will help you understand the facility's compliance history. These DMRs are what is used to influence EPA's ECHO database, and so the information you'll find on the database is also submitted to the department using this form. Some additional bits of useful information that you should try to collect are any violation reports, as I mentioned earlier, any special monitoring that was conducted as the result of any violations. Did the department see a violation, and did they follow up and study the impact of that violation? And then again, any correspondences between the facility and the department. Once you have all of this information, you should organize it in a familiar way because you will most likely be visiting it often. Some tips to help organize the information that we found useful was to create a spreadsheet with all of the DMR records showing when violations occurred, compared old effluent limits to the new ones, so put those limits and their monitoring requirements into a table so you can easily look back and forth and see if there's any change in the old permit versus what was proposed in the draft permit. And then also create an index of the files. I personally like to print out these files and have a hard copy so I can write on them and make notes. In that event, you find yourself having a very large folder or binder. In order to help navigate through that folder or binder, create an index of all the different documents that you have in there so you can quickly reference those documents when needed. The next step is when MDE releases a tentative determination and puts out the draft permit for public comment. Here you'll see an example of a tentative determination. Usually they start off by identifying who the facility is and where they're located. Then they include a summary of the permit limits and any special conditions that were put into the draft permit. Next, on the right-hand side of your screen, you'll see specific instructions on how to submit comments and the deadline for doing so. And then also, if you're interested in requesting a hearing, they will have specific instructions on how to do so and when the deadline is for doing that. In regards to the timeline for this specific permit, I requested a hearing on July 23rd of 2015, and the hearing was not until November 5th of 2015. So that gave us roughly 3 months between the time of requesting the hearing till the hearing was actually held. Once you request a hearing, the deadline for the comments may be extended beyond the hearing date. Now this is important because you'll notice in the tentative determination there is a deadline for comments, but by requesting that hearing, you're potentially opening up the opportunity to extend that comment period. And so you want to make sure to follow up with MDE on this and get assurance from them that the comment period is extended beyond the date of the hearing, and add that into your timeline of important dates. At this stage, you also want to consider doing another PI request and search for any additional documents that may have surfaced in between your first PI request and the time that the draft permit has been released. It's good practice to conduct PI requests periodically throughout the permitting process. Typically every 3 months is a good rule of thumb to go out there and collect information and try to see what's been going on with the facility. At this point, you want to start drafting all of your comments and start building your record. Remember, if you have information that is not submitted with your comments or not spoken during your testimony, then it's not on the record. So to build up your record, include everything in your comment letter and start with the most serious or concerning points first. This is where the volunteer attorneys through Chesapeake Legal Alliance really helped out. They were able to review the permits and provide insight that I was not able to at the time. They also were able to provide any examples of case law that may be applicable to that permit and any other legal restrictions into our comments. Now here's an example of the comment letter that we did submit, and you can briefly see some of the comments that we included on our letter. For the actual hearing, we took all of the points made in our comment letter and turned them into a verbal testimony. Now, it's worth noting that typically at the hearing, you will get roughly 3 to 5 minutes for a testimony. So in the event that you have more points to make than you can say in that time frame, it's a good practice to divide up those points and have a prepared testimony for someone else to give. And I want to emphasize this because as we talk about standing and the need to engage yourself in this permitting process and be on the record in order to have standing, this is a good opportunity to engage that person. Knowing that somebody else needs to provide comments, it's oftentimes intimidating to get up there and speak. And so in any case where a watershed group, a riverkeeper group, or somebody who has experience with this process can help draft or provide testimony for somebody else who may have standing and wants to enter into this process, then this is a good time to divide out those comments and during the hearing have as many individuals who may have standing provide testimony. After the hearing, MDE will issue a final determination. To put this timeline into perspective, we submitted comments a few days after the hearing on November 5th, 2015, and a final determination was not made until September of 2016. So that's almost 1 year from the time of the hearing that MDE took all the comments. They responded to those comments because they're required to respond to any comments that are submitted in the public hearing. And it took about 1 year for them to turn around a final determination. Specifically for this permit, in between the time of the hearing and the final determination of the permit, Allen Harim decided to shut down their plant in Cordova. I don't feel that we can take credit for them in closing in the area, but I'm sure that the pressure that we applied to them throughout this permitting process played a role in their decision making. The owner of the facility was quoted in a newspaper saying that Delaware was more friendly towards the industry and the operations that they were planning to conduct. And that's perfectly fine because I feel that by aggressively interjecting in the permitting process, we were able to make a statement towards what it means to do business in Maryland and how that relates to protecting our local quality. And that's exactly what opportunities you have by interjecting into this permitting process. For instance, let's say the facility did not close and that the MDE did issue a final determination. You'll see on the screen there the different steps. First, you want to review all of the responses to the public comments that MDE provided. Make sure that all of your questions, concerns, and suggestions were answered and that you're satisfied with them. If you are satisfied with it and you feel that you have a good permit, congratulate yourself. If you're not satisfied, consider a judicial review, as Mary mentioned. Once the permit is issued, continue to monitor that permit, the compliance of that permit, and track any violations. Again, if there are any violations, you may consider an enforcement action through the Clean Water Act citizen lawsuit. So now that we were able to give you the background on the Clean Water Act, introduce you to the NPDES permitting system in Maryland, and identify all of the avenues for which you can get involved in this permitting system, I want to explain how this can be a tool added to your water protection plan. The goal for creating this plan was for it to be a tool for watershed groups and their members, as well as community groups and citizens. We are in the process of creating an advertising and outreach toolkit to go along with this guide with the vision and hope that you will identify permitted facilities in your watershed or area, and along with your members and supporters, you will interject in the permitting process in a way to effectively strengthen the protection of our local water quality. If you already have a group of members and supporters that are interested in this type of permit review and compliance sweeps, then you could use this tool and organize a training on the useful tips provided within the guide. If you don't have a group already interested, but you have identified permitted facilities in your area, use this tool to engage existing local groups and interested stakeholders. From my experience, not a lot of local advocacy and planning groups know about the local NPDES permits in their areas, so when you approach them about a facility of concern, you now have this tool to take with you and to help navigate the process while working together. So as I mentioned, we're in the process of developing an outreach and advertising toolkit that hopefully all of the members here can take back to their networks and engage their communities, engage their members in the process of the NPDES permit. And with that, I think I'll bring it back around. And
great, thanks so much. We're going to go ahead and pull up the questions to see what questions we might have for our panelists and speakers today. And again, I wanted to kind of note that I apologize for the technical difficulty early on about the PowerPoint slides and not being able to see them. You can go to our website, which is chesapeakelegal.org, and you can download the PowerPoint presentation there and see those first couple slides to see anything that you might have missed from the presentation earlier on when we were having some issues flipping through the initial few slides. Also, the guide is located there. So now we'll take some questions and answers. Let's see if we have any there. Okay, great. So our first question is, how and where are the notices published? So that's a really good question. Does anybody want to start with that?
Sure. The notices of the permit applications are posted on the MDE website. MDE also is supposed to publish a notice in a newspaper, a generally circulated newspaper in the area that's affected, and they do it twice, once for 2 weeks running.
And it's important to note at this point, if you do identify a facility that you are concerned about, you can contact the department and ask to be put on a notification list for that facility when in fact their permit does expire or they apply for a renewal permit.
And Matt, actually, can you talk a little bit about, I know that you in conversations have mentioned that you've kind of established a relationship as a riverkeeper with other, or I should say with MDE, about the particular permits coming out in your area. Can you talk a little bit about what that looks like? Sure.
So over the years, we do a history of working on these issues, on these permits, and so we built a relationship with Maryland Department of the Environment, and they now notify us ahead of time of any new permits or any renewal permits that are about to come up in the Chop Tank on the Wye River. And so again, just to emphasize the importance of building that relationship, you're the best for MDE to turn around and notify you when those permits are up.
Yeah, that's a really great point. And you know, that may not be a first option for a citizen that's just starting in this process. But certainly over time, building that relationship even for a citizen and certain larger organizations or for river keepers to establish a relationship where there's a for the majority of the public. And I wanted to note here that we are coming close to the end of our dozen. I'm going to stay on more questions since there was a lot of really great material to try to get through. So if you still have questions or would like to hear us answer them, knowing that we're doing it through lunch hour, please feel free to do now. And someone did ask about presentations. They will be available, like I said, on the website, so you can access those audio recording, which we posted later. And then right now, as of today, you can access the presentation itself on the guide. So the next question we have here is, during the informational hearing, is it generally permitted to make an audio or visual recording? So actually, that's not an issue that I have ever dealt with. Is that any? Great, and that's a really great type of question that if you have that come up and you have a specific permit process that you're interested in, you can reach out to us and we can look into that specifically. A lot of times there will be very specific research questions that we can take a quick look at and get that answer for you. I do believe that in that context, it is available for citizens to do that themselves. And if the agency will or will not, that's kind of at their discretion, I think. But we could look into the specific future if need be. So the next question is there a regulatory frame in which MDE has to respond to PIA requests? That's a really great question.
I believe MDE is required to respond to your PI request within 30 days. And at that point, once they respond, they then issue a tracking number and review the files, or they will set up a timeline on when those files will be able to get to you.
And something to note there, and specifically in the information state, but in Maryland, they have an omnibus person who is set up to address messages that you come into contact with. For example, submit a PIA request, you don't get a response. So, and this information is all on the Maryland PIA request website, and some of this information is in the guide. And then also, for example, you request documents, but you think that you should have been a fee waiver. So that is a fee waiver for that the agency would have an example of a template form that you request. If they, the agency is asking you asking for a lot of money to get for. What I have here is if you rely upon something said before the agency during an informational meeting, should you have testimony to that effect? For example, to have local monitor the permit conditions. Matt is shaking his head, so I think that one.
And so this gets back to the point where he is required to respond to everything that you put in your comment letter or that you say. You hear something that and you want to hold them to it, include it in your comment letter that you submit after the hearing, or even mention it in your testimony.
Knowledge of seeing that in a citizen suit, although I know I have seen some examples where the agency had to do an anti-degradation analysis. So argument as to whether the anti-degradation policy analysis has been implemented appropriately or not, I think is going to be very fact and case specific on the anti-degradation analysis. And so maybe Jill can follow up on that.
EPA does have, I don't know if it's policies or standards that lay out what needs to go into an anti-degradation policy, and they've become more stringent over time. They will not approve water quality standards unless they contain these policies, and it's possible that if a policy is inadequate, that's an issue that could be brought up in a request for EPA to take enforcement action.
Okay, great. Thanks so much. And then we just had a note that the audio is going in and out a little bit, so we will try to address some of these questions and answers on our website so that you can get access to this in the future as well, in case you can't hear us now. So sorry about that. Everything seems to be good on our end, but so and the next question we have here is, how can you protest MDEs assigning a facility to a general permit rather than an individual permit? Great question. So a general permit versus an individual permit, it's going to really, in my limited experience so far, in this specific instance with a CAFO in particular, it's going to really depend on the type of facility. And so if in the context of CAFOs anyway, there has been some back and forth on whether a general permit or an individual permit is sufficient to meet those requirements. I think ultimately it goes back to whether the general permit is allowed to be issued for a facility or a host of facilities that are similar in type. So in theory, you would likely have to argue that that facility does not fit the category of general permit that's being issued, or that the general permit is not meeting the standard of the Clean Water Act. And those are slightly difficult arguments to make at times, and sometimes you have to kind of look at the permitting structure of the state to do that, and that has been done before. So for example, you can petition the EPA to say that a state is not properly enforcing the Clean Water Act, and you can give examples of that, and one could be, you know, the NPDES permitting process, and that you request essentially to EPA for the agency to take back their delegated authority for the state to implement their program. EPA has never done that before. And this is, again, talking a little bit more broadly about the structure generally and not just one individual facility. But there have been some instances of EPA coming out with some comments as to, you know, what the state is or is not doing appropriately that has resulted in some changes like that. But it's going to be pretty case specific, and you're going to want to make an argument like, you know, the general permit is not sufficiently meeting standards required by the Clean Water Act.
And the opportunity would come up to make those arguments when the facility needs to file to be included in the general permit. And so that might be at least the first opportunity to raise those arguments.
Right, and another thing to consider is that general permits themselves, when they're being issued, those are permits that you certainly want to take a look out for, and what types of facilities they are saying can apply to gain coverage under that general permit. And you can comment on those processes and also indicate whether you think particular types of facilities or particular types of applications should be used. So for example, Maryland has a general permit for the application of particular pesticides. And that was a general permit that is in the process of being renewed. The general permit is actually out of date right now, but we have been working with a client group to comment on that permit, and we're waiting right now for the determination to determine if they will continue to include a particular pesticide. So in this case, it's not a facility, it's the chemical itself being applied through that, but it's a general permit, a general NPDES permit. So we have another question here. Some more about questions and answers on the website. Yep, we will try to get those. Okay, great. So here's another question. This webinar is timely and important. How do environmental groups learn from others in other jurisdictions? That's a good question, Matt. Do you want to field that one first, and then I can kind of talk to it a little bit generally. So, you know, the NPDES permit process has existed for quite some time. The majority of states have delegated authority to implement the NPDES permit program. Only a handful of states do not have that delegated authority. And so learning from other jurisdictions is really important because the overarching framework of the NPDES permitting process should meet the federal standards. So because of that, most of your state programs are going to look very similarly. So in actually trying to broadcast, you know, that we were doing this training, we try to make it, you know, just get the message out there to people that although this training and the guide is very specific to Maryland, a lot of the overarching steps and process is going to be the same in every state. So you could take this guide and you could give it to somebody in Virginia and you could say, hey, this is the general process. Some of the logistics are going to be different, specifically, you know, your links and your resources. But ultimately, each of the states is required to implement a particular standard. And the majority of the things that states are implementing, sometimes they do go above and beyond, but a lot of times they are the floor that is set by the federal requirement for the Clean Water Act and not necessarily the ceiling. So again, you know, the state can go through and implement something that is a higher standard or requirement, but most states are at least starting or are required to start with the floor and are doing that. So sharing this information is absolutely very, very important. And it should be hopefully a good resource, this information, to other jurisdictions. So if you know others in other jurisdictions, please feel free to share that information. And we are certainly trying to get the word out. And on that note, if you have any tips or thoughts as how we can further share this information with other organizations that you know or if you would like us to provide a presentation to other people that you know or a group that you might be a part of, please let us know, and we'd be happy to try to facilitate getting this information out to more environmental groups in other jurisdictions. And let's see if we have any other questions. Well, I think that's everything that we have online. So thank you so much for joining us today, and we hope that this information will help you identify how you can participate in the Maryland NPDES program to advocate for healthy waterways in your local community. If you have any follow-up questions, please feel free to reach out to us. And webinar, you will get
All right.
stop recording, I guess. Yeah.
I think we must have,
Maybe we got on
put
early.
that screen up.
Yeah.